Welcome back. So we set the ball rolling immediately. The heartbeat of the nation is in our line of vision as we examine a myriad of issues: executive, judiciary relationship, civil liberties, the independence of the judiciary, which is a continuing debate that never seems to go out of fashion as a result of obvious current realities. And so joining us to have this all-important conversation is Senior Advocate of Nigeria, Mr. Adegboruwa. Good morning and welcome to the program.
Thank you. I'm glad to be here. Good
glad
morning,
to have
Nigerians.
You. Thank you so much, sir. So I'm going to start off straight with the dropping of the charges against the minors, even though that has seemed to resolve the issue. But there's still so many things to talk about in that space to understand. We have been told that the discontinuing of the trial and the taking over and discontinuing of that case by the Attorney General of the Federation is in line with the Administration of Criminal Justice Act, and it's fine. But the Defense Counsel is also asking that the charges be dropped against all the others. But the speed with which institutions responded to the order of Mr. President that those minors be released unconditionally, what can we glean about it if we viewed it independently, particularly about judicial independence?
Thank you very much. I think the case of the minors is a reflection of what is going on in the country generally. When you remember Chinua Achebe's things fall apart, a central not holding, because look at the charges, treasonable felony, mutiny, charging minors with offense of trying to overthrow the government. You take that to be the height of criminal prosecution, because if they were to be convicted, they will take the maximum penalty. And so you would think that if somebody is planning to overthrow the government and the person is to be tried, it will come from the highest quarters, that is the office of the Attorney General of the Federation. I do not think that such prosecution could take place without the knowledge of the Attorney General, being the chief law officer of the Federation. So you see that prosecutorial malady, where the Inspector General of Police is exercising discretion to charge minors for treasonable felony, for mutiny, for trying to overthrow a government, without the #1 chief law officer of the Federation in the know of that kind of prosecution. And then what is the proof of evidence? They were said to be holding water pipes, cables, Russian flag, allegedly, and then a letter from the Chief of Army Staff for investigation. You remember popular cases of treasonable felony, Chief M. Abiola, Chief Awolowo. So it comes to the height of criminal prosecution when you say somebody is trying to overthrow government. So that to me just shows that something is amiss. Somebody is not in charge. And it cascades down to every other aspect of this government. As you will see in many cases, a minister is being screened on the floor of the Senate, and suddenly you are told that the nomination has been withdrawn while she's still there to be screened. A lot of decisions taken when there is backlash and there's outrage, immediately it's reversed. It's something common with this administration. And just shows that, there's confusion. There seems to be some falling apart, at the center. And it's because largely, from my own observation, there seems to be some confusion. Like General Olusegun Obasanjo said recently that for you to seek to lead people, you should be prepared. There should be a blueprint, of what you want to do when you get to office. So it's not just a matter of entitlement mentality. You should have your team in place. You should have your program in place. As the American election is coasting to victory today, you would, in the next 2 days, people will announce their blueprint and agenda of how to take their country out of the woods. So I think that case of the minor is just totally unfortunate. And it's a reflection of the general confusion in this government.
I seek to understand that if President Bola Tinubu had not intervened by asking that the minors be released unconditionally, would the judiciary had responded and the Attorney General had responded with such swiftness, by discontinuing the trial? Even the police, we saw the police, the IG ordering that, top police officers be investigated for the way those minors were treated. So would those institutions had acted with such alacrity had President Tinubu not intervened?
I don't think Nigerians should be I want to use the word swayed by the so-called presidential intervention. I don't think that those children were arraigned without the knowledge of the presidency. So this is just political hypocrisy, if I can tell you, honestly. You recall that in August, the entire country was virtually aflame because the president and the government did not want Nigerians to protest. And these children were arrested since August. So it cannot be that the presidency was not aware that they were in custody from Kano, from Kaduna. And so I see somebody trying to take a political advantage of a situation that he caused. So I don't want to be swayed by the so-called presidential intervention to curry favor from the people of Nigeria. The responsibility of what happened lies straight at the desk of the president. So I don't think that it's his intervention that caused their release. It's the outrage. The president was trying to avoid embarrassment. The government was trying to avoid a situation whereby they will be defeated in court because the charges could not succeed. I've told you there was no evidence. For you to charge somebody for treasonable felony or mutiny, the person must be planning to overthrow the government. There must be conspiracy, like people who are planning coup. Not children who are 13 years old, not children who are minors. And the law is clear, the Child Rights Act is clear that you couldn't charge those people with that kind of offense. So the government did what it did to save face, to save embarrassment. The charge was going to collapse, and it was going to collapse on the head of the government. So what the president did was quickly to intervene to avoid the coming embarrassment to the government. So no credit should go to the president for intervening to save face from what should not have happened. But if the charge had continued, the judiciary would have, of course, taken a decision. There was no way those children could have been convicted for those offenses with which they were charged based on the evidence available.
It was interesting to see some walking back on words. I know when the issue came up, the spokesperson of the police had said after 7 years they could go on trial. It was an argument of minors. Some even, I think the IGP trade statement also, some of the children were, I understand, were maybe acting a script or so. And then at the end of the day, when you look at it critically, when you mention the fact that the IGP had gone on to charge them for treason without the knowledge of the AGF, it was difficult for me to process that because this was a widespread, and I am happy you mentioned the fact that the president had come. Everybody was in the know as far as this issue is concerned. But that speaks to a very larger issue as to the civic space, which is one of the things we would like you to speak to. If children who, quote and unquote, participated in this exercise are subjected to this kind of treatment, which I also want you to expatiate on, how far can we go with children when it comes to issues like this? Let's assume they were really involved in one thing or the other. If children can be treated like this, kept in from August to the end of October by a government that is supposed to protect them, what does it say about the civic space at the end of the day?
I think that generally from my observation, this current government is intolerant of opposition, is scared of criticism, and is doing its best to bear its fangs against those it considered to be enemies of the government. And so you see trumped up charges, you see clamp down on the press, on the media, you see people being bullied from speaking or from protesting. And so the general atmosphere is that human rights of the people of Nigeria is at the background in this current regime. That's one. Secondly is this. You can't beat somebody and say you shouldn't cry. I mean, look at the situation of Nigeria. The roads, you can't travel. They are bad. The option is to fly by air. The cost is not affordable. There is no electricity. The grid has just collapsed yesterday, probably for the 10th time in this year. So there is no electricity. The option is to buy a generator. To maintain that generator, you need fuel, you need diesel. So you will be dancing between NNPCL and Dangote and the oil marketers. And then you get sick because of this. You want to go to the hospitals, there are no drugs. So you then see that when people get to that stage where a government is pushing them down, the income is less and your expenditure is more. And then the government then says, don't protest. So you see that it shows a government that has no plan, no agenda. Because if you have a plan, you will come to the table, people will debate it, people will criticize you objectively, and you defend your plan. So the space currently in Nigeria is that opposition is not tolerated. Even politically, you will see that in virtually all the states, the ruling party is trying to capture virtually all the opposition states in order to enforce one-party state on our country. Section 11 of the Child Rights Act says that no child should be subjected to torture, should be subjected to violence. Of the nature of the people we saw in that viral video is torture, mentally, deprivation. They were not well fed. And then they were denied access to their parents and their legal practitioners. It took civil society organizations, Mr. Femi Falana, SAN, it took the End Back governance team to intervene because the children didn't have lawyers. Why would you charge underage children in court with such an offense without assistance of a legal practitioner? The same government set up the Legal Aid Council, whereby once you are taking somebody to court for a serious offense, you are the one to make arrangement through the Legal Aid Council to get representation for them. Under the Child Rights Act, a person is deemed to be a minor or a child if he's under 18. It's the same government that promulgated the law.
But we'll speak to this, Police PRO Muyiwa Adejobi said anyone above 7 years can be arraigned in court. What's your legal interpretation of that? Of course, the police has a legal department in all its formations.
Oh yes, minors can be charged under special arrangements if, for instance, they commit offense along with adults. But in this case, in particular for the minors who were arrested in Kaduna and Kano, they were arrested for protesting. Not that they committed a criminal offense in the nature of rape, in the nature of murder. They were arrested for exercising their fundamental right to protest. And that's why there's national outrage. If a child commits an offense in the course of ordinary criminal liability, of course it can be arraigned in the family court, it can be arraigned in the juvenile court under special arrangement, but not in this circumstance whereby people trooped out to the street to protest against bad governance. And I'm emphasizing what led to the protest is that people are dissatisfied with this government. People are angry that a government came and has no economic policy to better the lives of the people. The exchange rate is ballooning every day. The cost of fuel and energy is skyrocketing, and people are suffering. There's hunger, there's mass poverty. And so the people then trooped out to the street to protest, and then you clamp them up, children from their various states, and transported them to Abuja, and then kept them in custody for August, for September, no access, and in October, you marched them to court for treasonable felony without evidence. So that's why I said nobody should clap for the president. Indeed, what Nigerians should demand for is a commission of inquiry, so that everyone who is responsible or involved in this should be brought to justice.
Let us say, I'm curious, and I'm going to call everybody out on this one. What you've explained so far seems to me like every lawyer should know the basics of this. There's an AGF, who is a senior advocate. There is the IGP, who I'm sure has senior advocate working in the police. There's a judge sitting over this case. So where did we miss it to the point where children were brought in, kept for 3 months, arraigned in court, and it took a last-minute decision of the president for everyone to realize, oh, we were going on the wrong path? What does that speak to our judiciary and the interpretation of the things we're seeing?
Well, I think that generally, before you consent to assign a date for hearing of a case, it's expected that you will read the case file. And in particular, the presiding officer will seek to look at the evidence available. But when a case is brought before a judge, there is a limit to the intervention he can give in terms of preventing the hearing. His responsibility is to offer everybody the opportunity to come before him to be heard. That's why we say the eye of the judge is closed. If you see the symbol of the judiciary of the lady with a scarf over her face, he's not supposed to know you, he's not supposed to know the other side. Give the opportunity to be heard. But I expected, on the day the charges were being read, for my lord, the presiding officer, to interrogate the prosecution who brought the charges, looking at the children, their state, and probably direct that they be taken back to be properly catered for, and then make inquiry from the office of the Attorney General as to why the police is allowed to prosecute such serious offenses. Because ordinarily, I don't expect the police to file a charge of mutiny, of treasonable felony, without consulting with the office of the Attorney General. And you see what has happened now is that the Attorney General came back to exercise his responsibility under the Constitution to withdraw the charge. So generally for me, it's an indictment on the system of administration of justice in terms of the embarrassment it's caused this nation that such offense, such matter came to this stage without people who should know being in the know of it allegedly. And having that having happened now is for us to take it as a lesson, because there are people who are still facing same charges in Borno State, in other parts of the country, who are languishing. I was even told that there are part of NSAS protesters that are still in custody up till now, which shows the intolerance of the government, as I made earlier. So it's important that when we claim to run an administration that is oiled through democracy, you should allow people the opportunity for dissent, for protest, because it's guaranteed by the Constitution. After all, that's what brought the current president to power. It was through protest, you know, in various places. I mean, challenging the status quo and insisting. I mean, while the other president was in power, the current president went to Abeokuta and declared that he's entitled to run. He protested, and the heavens didn't fall. So I am appealing to the president, I mean, to respect the Constitution, to allow citizens the space to make their expressions, to make their views known, especially when they are affected by programs that is causing poverty, that is causing hunger, that is causing economic adversity for our people.
And if we're practicing constitutional democracy, it behoves of the judiciary to also interpret what the Constitution is, and for everyone to abide by the rule of law. And some would say we should not project the judiciary to look like it's totally corrupt and irresponsible. But we must also put the issues out there such that the judiciary can adjust where need be. Speaking of which, I wonder if you have chanced upon reports about politicians being, interfering with the judicial process through the sale of judgments, building houses for the judiciary. While it is important for the judiciary to be independent, perhaps we should take a track now, and then I will land on this question.
Those that are not criminally liable under the law, those are the people that are young ones below the age of 7. Once you are more than 7, you can be charged to court. The only thing is that you need to follow certain procedures to do that. But none of them is less than 7. I think the youngest should be 13. The fact that you are a 13-year-old doesn't mean you cannot be charged to court. So anybody, even the Children and Young Persons Act, they can still charge you to court because you are 13-year-old. You can go to court. So,
of course, we're referring to this point made by the Force Public Relations Officer, but we've since moved on to that, and we're now looking at the independence of the judiciary. This concern about executive interference through the sale of judgments, through bribery of the judiciary, construction of houses for the judiciary, how can we insulate the bench from this undue influence such that the judicial process can go smooth sail without this undue influence?
Bukola, let me tell you, as I sit here, I refuse to believe that the judiciary is corrupt. And I'll tell you why. I go to those courts every day. And I present my arguments, I file my cases, I get judgments, I lose some. People who claim that the judiciary is corrupt in terms of you can buy a judgment, come up with the evidence. Because it's a challenge for us if we keep on this narrative. I cannot tell you to say that maybe in some circumstances, people may be exerting influences on judges. But I tell you, as I sit here, close to 30 years of practice in and out of those courts now, I can file a case on your behalf today and get judgment without you knowing the judge, without you paying a dime. I got one of those judgments yesterday, I got some last week, and I didn't know anybody. But that's not to say that there may not be few instances when circumstances of extraneous interference may happen in the judiciary. And those ones are being painted in a way to make it look like it's the norm, but that's not correct. And I tell you before God. So when we have those instances when anybody can justify the allegation that a judge is corrupt, we should send them to jail. And you have seen examples. That's why the National Judicial Council is there. So what I like to say about judicial independence is that it's the executive, no funding. Go to the Federal High Court. You will be shocked that a particular court, a judge cannot sit down to preside over proceedings. He has to get up every now and then because the chairs have collapsed. There's no electricity supply. There are no personnel. There are judges in Lagos who are sitting over 1,000 cases. And they are human beings. So the problem with the judiciary actually is funding. And that's what the executive is doing to starve the judiciary of funds in order to ensure that cases drag. Because when you look at the system that we have, the people committing infractions against people's rights is the executive. The police will arrest you. The executive will revoke your land. The commissioner will do one or two things. So most cases in court are against executive rascality and impunity. So it's the executive that is starving judiciary and putting them down to ensure that when they do these things and you want to cry against it, they go to court. The people who are doing the election petitions, they are the politicians, they are the executive. So we must all unite to say, fund the judiciary. And when you have done that, let the institution set up by the judiciary for checkmating its rascally members be put to use so that when we have an occasion like that, we can all say, send them to prison.
Okay, so how should we fund the judiciary? How should the executive fund the judiciary? Because there's a Nyesom Wike who builds infrastructure for them. People will say, oh, he's building it to curry favors. The government increases their salary, they're increasing it for favors and all of that. So what's the best way to work on this and make sure that the perception is really the fact that, look, this is what we can do for the judiciary and it has nothing to do with currying favor, without speaking for them? Because you've talked about they are starving the judiciary for whatever reasons or intent.
Well, for me, it's for the National Assembly. They are the one who prepared the appropriation. They're the one who approves. And I commend those who are there now. For the first time in many years, we witnessed an upsurge in the allocation to judiciary in the current budget. That should increase as we go along. Then secondly, when you release those funds, let it go to the account of the judiciary directly. Let no governor be the one to approve the budget of the judiciary, because that's the influence we're talking about.
Should governors be building houses for judges?
No, that's the point I'm making, that make the judiciary independent. Let them buy their own cars. Let them build their own houses. Let them pay their own staff. Let them have complete independence. The National Assembly has a National Assembly Commission that recruits staff, that pays the staff, and they're the ones who are responsible for infrastructure of their members. So the same thing should happen through the judiciary. So that when you do all this and they are well taken care of, we can then go to the issue to say, every time we see an infraction of semblance of corruption, of course, we'll then be able to deal with them. But to say that the FCT minister built houses for the judiciary is neither here nor there. And I'll tell you why. The Federal Capital Territory is like a state on its own. And if you want to take land from somebody and use it for construction of buildings, whether for ministers, whether for the executive or for the legislature, maybe the error was in inviting the Chief Justice of Nigeria to attend such ceremony and then disclosing to her embarrassment that the land was revoked from Julius Berger, And people say, if Julius Berger decides to go to court, who is going to preside over the case of Julius Berger, since the buildings were being allocated to the judiciary? I think that was totally wrong. But for me, once those opportunities arise, it should be handed over to judiciary completely, so that it will be allocation of who gets what will not be a matter for the FCT minister.
Okay, sorry. Senior advocate, at the end of the day, what we're dealing with here is perception. The public perception, which we must try to regain as much as possible, because at the end of the day, if they don't believe that the judiciary is really independent, what can we really do? But as we begin to wind down, because I hand over to Bukola, the issue of conflicting court order. The CJN has taken over, I think, for a few weeks now, a few months now. She says she's intolerant to corruption. She's going to hit the ground running. I don't know what you have seen she's done so far, because part of the judgment and conflicting orders is setting some states that have 2 houses of assembly, 2 emirs, and there are too many tools that are coming from court, and it's just a mess. So what would you be saying to the CJN in terms of the level of urgency that needs to be corrected as quickly as possible so we can begin to regain trust for that institution?
I will be saying to Nigerians not to unduly focus on the Chief Justice of Nigeria. And I'll tell you why. If we go through the Constitution, no special responsibility is conferred on the Chief Justice other than being the head of the Supreme Court, chairman of the National Judicial Council, and also heads of certain agencies. So the CJN in Abuja, for instance, cannot determine what happens to the High Court in Lagos. She cannot determine what happens in the Federal High Court in Abuja. Neither will she determine what happens in the High Court in Kano or in Rivers State, except to exercise her disciplinary jurisdiction through the National Judicial Council, which is purely administrative. So what you have is that the outrage is against the seeming abuse of ex parte orders, of conflicting decisions by one court in Kano, in Rivers. It is for the chief judges of those states, either in Kano, whether in Rivers or any other place, to ensure that, because you can't assign a case unless the chief judge is aware. And when those cases are already being thrown up that way, they have to find a way to ensure that, you do not allow the opportunity for ex parte orders to be abused. Because telling you, sir, there are genuine cases that warrant urgency for judges to grant ex parte. It's the abuse that we're complaining of. So I don't want us to get the impression that, we shouldn't allow judges to grant ex parte orders. Speaking to what we should tell...
Politicians have access to this ex parte a lot.
I have access to ex parte orders too, I'm telling you the truth. But speaking to what you have said, if I'm talking to the CJN, my Lord, the Honorable the Chief Justice, is to digitalize the courts. Let's reduce human influence in terms of assignment of cases. Litigants should not know who their judge will be before they file their case. Litigants should not have an idea of who is going to preside over the dispute they have taken to the court. So digitalize the process. And then, of course, make the process also to go digital in terms of filing, in terms of assignment of days, electronic recording. And then you can then ensure that once a judgment is out, it's easily uploaded to the website of that particular court, so you avoid conflict in decisions of those courts. I will be speaking to the Chief Justice to say that they can formulate policies and get a uniform model for courts, so that when you get to anywhere, this is a high court. It has electricity, it is built in a place that has security, it has facilities. You then say that this is a high court. I'll be speaking to my Lord to unify the rules of practice. Because presently, if I leave Lagos to go and practice in Delta, I have to study the rules of their statute to understand what the nature of their practice is. Indeed. There. But by the time I get to the Court of Appeal, I then have a uniform system of judges all over the country. Indeed. Who are in the Court of Appeal and also in the Supreme Court.
And that call for the digitalization of the courts is echoing even from members of the bench who had served in the past as well. So much to touch on, but we must thank you very much for your time and for your contributions to the program this morning. We've been speaking with Senior Advocate of Nigeria, Mr. Adegboruwa. Thank you so much for your time, sir.
My pleasure. Thank you.
And from here, we switch gears to another important aspect of development. This time, we'll be looking at the welfare of Nigerians in diaspora and, of course, those socioeconomic issues that also serve as push factors for Nigerians to seek greener pastures abroad. Stay with us. We'll be right back.